So if you're thinking about starting a business here in India, you've almost definitely heard the term LLP, right? Limited Liability Partnership. But what does it actually mean? Today, we're going to slice through all that legal jargon and really explain the LLP Act of 2008 in a way that matters for you, the person actually building a business. Let's jump right in.
You know, every single entrepreneur hits this exact fork in the road. It's that first big decision. Do you go for the simple, straightforward partnership, or do you take on the more complex but protective structure of a company? It's really the classic dilemma.
And here's the deal, right? The trade-off. A traditional partnership, super easy to set up. But, and this is a huge but, it comes with this massive risk, unlimited liability. If the business goes under, creditors can come after your personal assets. We're talking your house, your car, everything. On the other hand, a company, well, it shields you from all that. But man, it can bury you in paperwork, endless meetings, and complicated rules that can really slow you down when you're just trying to get off the ground. But what if you didn't have to choose? What if you could get the best of both? You know, the freedom and flexibility of a partnership combined with that ironclad protective shield of a company. Well, that's exactly why the Limited Liability Partnership Act was created back in 2008. It was designed to solve this very problem.
Okay, Section 1. Let's get down to basics. So, what even is an LLP at its core? Let's break down the definition and really see what makes this thing tick.
The best way to think about an LLP is like a hybrid. It's a formal business structure what the law calls a body corporate, and it basically cherry-picks the absolute best features from both partnerships and companies. So you get that operational ease of a partnership with the critical must-have limited liability protection you get from a company.
So an LLP has a few key traits you gotta know. First, it's a separate legal entity. This means the business itself can own property or even get sued, completely separate from you, the partners. It also has something called perpetual succession, which is just a fancy way of saying the business doesn't just die if a partner leaves, it keeps going. And of course, the big one, liability is limited. Everything is governed by a written agreement between the partners, and, this is important, it has to be a for-profit business.
All right, Section 2, building your team. Now that we've got the structure down, let's talk about the people. Who can actually form an LLP, and what are the specific roles that absolutely have to be filled?
The rules for who can be a partner are actually pretty flexible. Any individual can be a partner, and so can another company, or even another LLP. The main restrictions are really just common sense, you know? They're designed to make sure that every partner is legally competent and financially stable.
Now, within your team of partners, the law says there's a special role you need to fill, the designated partner. And every single LLP has to have at least 2 of them. You can think of these folks as the captains of the ship. They're the ones who are ultimately responsible for making sure the LLP is playing by all the rules.
And the second big rule here is about residency. The government wants to make sure there's always someone on the ground in India who can be held legally accountable for the business. That's why the law says at least one of those designated partners has to be a resident of India. So what does resident actually mean? The Act gets really specific here. It's not about your citizenship, it's all about your physical presence in the country. A person is considered a resident if they've stayed in India for at least 120 days during that financial year. Simple as that.
And believe me, this role is way more than just a title. It carries some serious legal weight. Designated partners are the ones who are personally responsible for making sure all the filings are done right and on time. And if the LLP gets hit with penalties for not following the rules, yep, those fines come straight out of the designated partner's own pockets.
Section 3, the liability shield. Okay, let's get to the main event. This is the single most important feature of an LLP. It's what gives it its name and all of its power. Section 28 of the Act says it all perfectly. A partner is not personally liable for the obligation of LLP. That one sentence, that's the legal wall that separates your personal finances from the business's debts and any lawsuits. This is the whole ballgame.
But, and you have to pay attention to this, that shield isn't indestructible. In day-to-day operations, yeah, you're protected. You're safe from the business's debts and even from some rogue action another partner might take without your approval. However, if any partner acts with the intent to defraud creditors or anyone else, the law shatters that shield. For any partner involved in fraud, their liability becomes unlimited, putting their personal assets right back in the firing line.
Section 4, running your business. Okay, so you've set up your LLP, you understand your liability, now what? What do you actually have to do to keep this thing running smoothly and, legally?
Okay, so every single year, there are two filings that are absolutely critical. First, you've got the Statement of Account and Solvency, which is basically a formal declaration that your LLP is financially healthy. Second, there's the annual return. The deadlines on these are super strict, so your designated partners really need to have these dates circled in bright red on their calendars.
And to back up those filings, you have to have your financial house in order. The Act says you have to maintain proper books of account using the double entry system. You get a choice between a cash or accrual basis, but the really key rules are that your records have to be accurate and you have to keep them at your registered office for at least 8 years.
Section 5. The end of the road. You know, every business journey eventually comes to an end. So how exactly does an LLP legally close its doors?
Well, the law gives you two main ways to dissolve the business. The first one is voluntary. Pretty simple. The partners just decide together to close up shop. But the second way is when a legal tribunal steps in and forces the LLP to wind up. This can happen if you operate with fewer than 2 partners for too long. But listen to this last one. A tribunal can shut you down for failing to make those annual filings for 5 consecutive years. It's a really powerful reminder of just how critical all that compliance stuff really is.
So what's the big takeaway here? The LLP really does offer this unique sweet spot. It's way less complex than a full-blown company, but it gives you so much more protection than a simple partnership. So the real question for you is, does this powerful hybrid model provide the right foundation for your big idea? Thanks for tuning into this explainer.